Welcome to Retail Retold, the stories behind how that store landed in your neighborhood. I'm Chris Ressa, in conversation with the people and stories shaping retail and real estate. Brought to you by DLC. Welcome to Retail Retold, everyone. I'm your host, Chris Ressa, and today I am joined by Scott Fleischer. Scott is a bankruptcy counsel at Barclay Damon. I'm excited for him to be here today. Welcome to the show, Scott.
Appreciate you having me. Thanks, Chris.
For those who don't know, Scott and I have sat shoulder to shoulder in bankruptcy court before at auctions. This is an exciting one because we have a good story here to tell. But before we get started, Scott, why don't you tell us a little bit about who you are and what you do?
Sure, appreciate that. So as mentioned, Chris, partner at Barclay Damon, focus on bankruptcy, and specifically most of my practice is retail bankruptcies. And within that, representing landlords, typically groups of landlords, when their retail tenants file. So very niche area, a lot of experience in that. It's a really interesting space.
Awesome. And so you've worked on a bunch of different cases. And today we're going to talk about the Chuck E. Cheese case because that turned out to be a really good outcome. So I'll probably stop you along the way and ask you questions, but why don't you give us your take on why that was a good outcome and the story behind that?
Sure. It had a lot of interesting developments in it, and especially just because of when it took place, right? So they filed in June of 2020. So they were actually probably one of the last ones of that first COVID wave once it first hit. And they were looking to reorganize. And in doing so, they filed this motion that every retail debtor was filing at the time, which was to delay the payment of essentially the first 2 months of rent in the case. And before COVID hit, I can tell you confidently that almost no bankruptcy lawyer actually realized that that provision existed in the bankruptcy code. It was there, but it was never ever used, right? But it is staring us all right in the face. A 60-day delay is possible for cause. So that's just some general standard that judges have a lot of discretion with. So we were faced with that sort of right off the bat, and there wasn't a ton we could do.
In most bankruptcy, that's not the case. Typically, once they enter, they're required to pay rent along the way, correct?
Exactly right. So there is that pre and post bankruptcy split, right? So once the filing hits, yes, they're required under the bankruptcy code to perform under the lease going forward. Everything that was pre-bankruptcy remains pre-bankruptcy and gets dealt with later.
But this was a little different because they found a provision that was in the code that wasn't widely used.
That's right. And ironically, it's actually in the same provision that requires performance post-bankruptcy. But then there's this little subsection below that all of us just ignored because no one ever used it. And they were one of the many. I think Modell's was probably the first one to use it because they had filed maybe 2 or 3 weeks before COVID really hit the U.S. And from that point on, every retail debtor was filing the same motion, and judges were routinely granting it.
Got it. And so continue the story.
Yeah, sure. So they filed this motion. We were all expecting it, going in, of course. And what we did is we got, that was sort of the beginning of the positive outcomes in this case for the landlord creditor side. One, we got them to put in that court order that they had to maintain insurance during any time where they didn't have to necessarily pay rent. And we got them to put in that right when that 60-day period expired, that's when those 2 months of rent would have to be paid. Because that's sort of the rub in all those cases where the 60-day delay is sought is, okay, you're going to, agree to that, right, judge? But there's no provision then saying when it actually comes due, right? Because these are monthly rental obligations.
So that's not an abatement of that rent. The code doesn't allow them to abate that rent. It allows them just to delay it.
Correct. Correct.
Okay.
Just a delay. So those were two aspects, right? Sort of the beginning of this case that we thought, okay, maybe the judge is looking at this one closely and is sort of looking out for creditors a little more than usual, right? Typically, bankruptcy judges very debtor friendly, so they would favor a retailer whenever they could in this type of situation.
Got it. Okay. So keep going.
So then the next step was, okay, we figure we're going to get our 2 months of rent. It's going to come due. It was, right around August.
Let me. You're saying we. When you say we, you
Yeah.
mean who are you referring to?
Landlord clients, right?
Okay.
So I'm just, that's what I do, as you know, every day. So I sort of think of it as a we situation, right? Fighting for landlords' rights there.
And the and going back real quick, you wanted them to require that they maintained insurance. Why?
Yeah, I mean, especially at that time, right, with government shutdowns or other limitations on how stores could be operated, it was a especially dangerous time, for example, to lose insurance for some period, because if the store was down, no one could go in it. There could be even more problems than usual, operationally or otherwise. So that was just something we had on our mind as a general real estate matter, and we got it incorporated into the bankruptcy return.
Great. Okay. Keep
Yeah,
going.
so then we got that sort of good relief started. Then rent was coming due after that 2 month delay. Then all of a sudden they file another motion, and it is, to your point, to abate the rent all of a sudden. So they didn't seek that relief initially purposefully, because they figured, let's get the delay first, see how the case is moving, then we can file our motion to abate. And while that motion is pending, we probably won't pay rent, for the most part, and give ourselves like a de facto extension on the 60 days that they already got. So that was obviously not met kindly by the landlord community. And this was a hotly contested topic outside of bankruptcy at the time, right? Could rent be abated because of the government shutdowns, limited capacity, those sort of things? So the same issues we were seeing in real estate litigation or negotiations outside of bankruptcy were coming into play in bankruptcy. Force majeure, impossibility, right? All those lease provisions under state law were getting a really hard look. So that was the basis of Chuck E. Cheese's motion. And because it was so complicated and they have obviously locations around the country, it wasn't something where it was just bankruptcy law that could decide it, right? There were a lot of obviously different provisions in individual leases, a lot of different state laws to consider. So it was going to be a process that went on for some time following the filing of that motion.
Got it. So then what happened?
So it it was starting to proceed. There was going to be some procedures laid out to deal with this right abated rent or proposed abated rent. And, personally, I sort of saw what was going on in litigation outside, and there were some decisions going on the landlord's way, some decisions going the tenant's way. And I just thought for our client's sake, it was actually best to let other landlords sort of lead the litigation charge and see how those played out before we decided to get into the fray. I think importantly, you don't want to spend money litigating when you don't have to yet. I wanted to take the judge's temperature on those issues. So even though, we weren't among the first, let's say, to file an objection, take discovery, litigate the issue, I still attended the virtual hearings that were taking place on the other landlords who did start that litigation earlier, and sort of saw that the judge seemed to be trending in a positive direction toward the landlord side, actually, in a lot of circumstances, which is rare, again, for bankruptcy cases. Landlord counsel were not used to being on the easy side or the winning side of things as much. We do what we can. So that was actually a good reason to sort of hang back, see what was going on, And then once you saw that opening that the judge seemed to be leaning in that direction, then get more involved, for our client's side specifically. And it ended up that for many, many leases, for many, many landlords, the judge denied Chuck E. Cheese's abatement motion. There were a ton of lease provisions that provided specifically for the ongoing obligation to pay rent despite any government shutdowns, limited capacity, things like that. So basically the judge's hands were tied, right? That's what the lease provided for. There was no other clause like impossibility that could change that. So that's really where the judge's decision went, and it allowed our clients to sort of take advantage of the groundwork that had been done by others without having to, again, jump into the fray right away and spend a ton of money. And that facilitated, a good outcome in the case.
Got it. And so how, given all the circumstances, how did Chuck E. Cheese end up prevailing and making it out?
Yeah, I mean, luckily they still had the support of their lenders, who, as you've probably seen in bankruptcy cases, are really the ones sort of behind the scenes leading the case, right? They hold the purse strings on these debtors, so they have, ton of pre-bankruptcy secured debt. Then they'll usually get a loan, right, called a DIP financing loan from those same secured lenders during the case. So as long as they're still in support of a reorganization, which is what ended up happening in this case, then you have the ability to, again, have leases stick, have financing for the company going forward. And I think at that time, there was such little prospect for a sale, right? For a third party to come in and say, we're going to buy the Chuck E. Cheese chain, right? Think of late 2020. No
Yeah,
one was doing transactions at that time. So it was really reorg or bust. And the lenders probably just figured, let's give this company a shot, see if we can recover, as much as we can. And they ended up doing like a debt for equity swap, right? So secured lenders traded in their remaining debt position, took equity in the reorganized Chuck E. Cheese.
got it. And was this a long bankruptcy?
Not terribly, actually. And I think one of the reasons was because, again, lenders, the ones who are watching the finances of the case most closely. So again, they filed late June, and the plan was confirmed and went effective, which is essentially the end of the case, by December. So I think you've seen plenty of other circumstances where cases go on much longer than that. And again, here, once they were losing on the abatement motion in a lot of circumstances, there was a ton of rent all of a sudden coming due. So not only did they have to pay, right, that post-bankruptcy rent, the 2 months plus that had been at first delayed and then attempted to be abated, if they wanted to keep leases going forward, they had to cure all the defaults pre-bankruptcy as well. So in a lot of these, there was a ton of rent outstanding. And of course, they could always negotiate, try and get a landlord to do a lease amendment and so forth. But unless a landlord agrees, they have to get paid everything that was owed. So that's a reason to get out of bankruptcy, right? Because you don't want those obligations to keep accruing.
And but one of the things with that one is there's a lot of times there's like these pre-planned bankruptcies where people are super efficient and organized. They go in, there's deals already struck, and the bankruptcy's pretty quick and they get out quickly. This one, because of COVID and everything that happened so fast, wasn't as tight in a nice, pretty bow going in, correct?
That's right. There was an idea coming in, with those lenders that they would probably end up needing to sort of take over the company. But you're absolutely right. Given the timing, they didn't have all that to work with, right? Like a Container Store recently, right? That was in and out immediately, no issues in the case. We're going to pay everyone. We have a deal in place. It was certainly not like that at all. So to come from that point to have a case run for 5 months or so was quite an accomplishment, and especially right, it's been a long time since that case ended already. Chuck E. Cheese seems to be doing just fine. So they did seem to manage to thread that needle a bit, right? As to maybe they did take the right leases at that time. Maybe they did, take advantage of the unfortunate circumstances, right, that forced them into bankruptcy. But maybe it made them take a closer look at the business earlier than anticipated and come out stronger on the other side.
Got it. Did they end up closing a lot of stores?
Not a ton, not a ton. From what I remember, they probably kept, I think it was like 80% of them or so. They did a lot, which again means they paid a lot of money to landlords all at one time, right? They paid all those post bankruptcy obligations that had been accruing, all the right, because they filed late June, so by that time there was probably unpaid March, April, May, and June rent under those leases, right? Because there were all the eviction moratoriums and so forth. So they were a little shielded, right, from getting, evicted pre-bankruptcy like a normal retailer would be exposed to.
Awesome. So just going back, you just mentioned Container Store. Can you give a little insight on that and how that was different and what happened?
Yeah, so that was a almost opposite scenario, right? They weren't as distressed, operationally speaking, right? They decided we want to accomplish a strictly financial restructuring. So we're going to do what you said, like a pre-packaged type bankruptcy. So they have something called a restructuring support agreement, right? Which has all of the major parties, all of the different lender groups, the debtors or soon to be debtors, right? The Container Store. And they come up with an agreement of exactly what's going to happen in the bankruptcy case, including the required timing. So if Container Store didn't exit bankruptcy within, let's say, 45 days of filing, that would have been a default under that restructuring support agreement and could have jeopardized the whole thing. So everyone was on the same page about getting just a real quick reorg done. And what they decided to do was pay all creditors in full, no matter what, right? So at that point, they had no incentive to get rid of any leases, right? So they kept them all. Because if you're paying creditors in full and you reject a lease, all of a sudden you have a claim from a landlord for any pre-bankruptcy rent plus rejection damages, which can be a year of rent, or in a really long-term lease, could be up to 3 years of rent. So they would be on the hook for that entire amount in full. So there was no reason to do that. We'll see if they come to regret not addressing the lease portfolio a bit, right? We're working through Joanne, obviously, right now, which had a very similar outlook to Container Store. They had a quick bankruptcy, paid everyone, and then months later, here they are back. So hopefully Container Store can avoid that outcome.
Got it. So back to the core story, Chuck E. Cheese. What do you think was like the outcome that made this a total, that ended up being a bright spot win for everybody?
Yeah, I think it was again, like that treatment of lease obligations. It sort of was a signal maybe to other retailers who had those ideas going forward, right? That it's not that easy, right? So you need to pay some rent. Obviously, landlords are going to be willing to do deals. So I think it was sort of a coming together of the landlord and tenant side in retail real estate, and hopefully sort of paved the way for other bankruptcies to avoid some of these issues. And I think it's safe to say that it did work, at least to some degree, because we didn't see a ton more of those abatement type motions, right? We did keep seeing the 60-day delay motions until the government shutdowns really stopped. But there wasn't a ton of litigation within bankruptcy anymore. So I think because it was so heavily contested and so many parties participated, it did lay that groundwork for future cases.
And it was a successful outcome for Chuck E. Cheese from a store portfolio. They're still operating today, and here we are.
Yeah, exactly.
Scott, anything else you would want to add as it relates to the Chuck E. Cheese case, bankruptcy, or, you just mentioned Container Store. Anything you'd want to add?
Yeah, it's just a very interesting time to be in the bankruptcy world, especially in retail real estate, right? You mentioned Joanne is back in right after that quick one. Party City is back in after a reorg outcome. So I do wonder if there's going to be sort of more thought put into right the first bankruptcies, some of these retailers as they're going through it, knowing sort of some of the pitfalls that other retailers have recently gone into. So I'd be interested to see what may change in future cases for that. And then just one other interesting case going on right now is the franchise group one, right? So that has Pet Supplies Plus and Vitamin Shop and Buddies and American Freight. And there's a hearing tomorrow that's supposed to be on their disclosure statement, meaning just sort of allowing them to proceed to a plan, which is the exit of the case. There's a big issue that's very, very contested, which is whether franchise groups' counsel can represent them, or did they have conflicts coming into the case that they can't fix. So I'm interested to see that. That's a very rare fight to take place in a especially in a retail bankruptcy case in particular. So be interested to see what happens with that, and if their counsel has to be substituted, what happens to the reorganization groundwork that they've laid so far. So it's something to look out for in the next, couple of weeks.
Yeah, I one of the things that's been a takeaway for me and spending time with you and you know closer to some of these cases is there's always this it feels like headline news kind of buckets the issues on one side, and I think there's really three potential issues. Like, is it, and the one that I read a lot about is like there's too many stores, they're overstored. That's one. And so can it shed some stores? The second piece is there too much debt? It's not really a four-wall store thing. I think one of the things going into the first Joanne was that there was a case was many of the stores on a four-wall basis were profitable. Mm-hmm. And then the third is the business model just obsolete now? Those are like the three big things. And it seems like there's a lot of emphasis on the store one or that the financing one. We mentioned, obviously, there was a quick reorg with the Container Store, and they restructured some things. And so not really focused, the bankruptcy wasn't focused on the lease portfolio. But to me, that's always interesting, is like, what's really causing the issue here? And obviously there's always some combination, but I'll hear people say like, well, they came out, but they didn't address this on a store level. And oftentimes these retailers were so successful and expanded so much because the store worked and still works, but maybe how they got there, right? How they structured the financial wherewithal to get there there's been pressure put on that. So I always find that interesting.
Yeah, I'm 100% with you. I think that's probably the biggest misconception of the whole retail bankruptcy world, right?
Yeah.
It's just too many stores, what's going on in the industry. But if people looked into it at all, we realized that most of these cases are not started because of a lease portfolio issue. It's sort of incidental to bigger debt issues, right? There's private equity transactions and so forth that kick these off and load companies with debt. So there's definitely a lot more to it than people realize at first. And then I think even while the cases are going on, right, there's misconceptions about sort of what can happen with leases and the like. So I'm with you. There's a ton of factors going on. Sometimes companies just don't need to be around anymore, or they should be a little bit smaller, right? There's,
Yeah.
as you know as well as anyone, just a changing definition of what is a shopping center tenant, right? So there's going to be that natural turnover. And I think as time goes on, that turnover will happen even quicker, and that'll just facilitate more of these bankruptcies. But especially over the last few years, I've seen this from clients a lot more, which is bankruptcies are not just negative. They can be significant opportunities to get certain spaces back, whether that's to just get market rent, to facilitate a redevelopment of a shopping center. So there's a lot more out there than just someone files for bankruptcy and, oh, they could go out of business. That doesn't happen like that.
Awesome. Well, Scott, this was fantastic. Thanks for sharing your insights. Really appreciate it. And yeah, hopefully I don't have to work with you all that much.
Yeah, we'll see about that. I mean, there's a lot going on right now. So,
all right. I'll talk to you. Thanks so
okay.
much.
Bye.
Stay on for a sec, Scott.
Yeah.
Appreciate you watching. Hit subscribe. See you in the next one.